Hi guys, today in this video I am going to speak about the historical aspect of international taxation and double taxation avoidance agreements DTAAs. Every country wishes to function in a manner which helps to achieve its desired objective of economic growth and development, uplifting the socially weaker section of the society and generating the employment opportunities in order to achieve one of its major source of revenue, which is collection of taxes. The incidence of tax in a country may be on its citizens, residents or non-residents. Tax incidence is said to fall upon that group of persons which ultimately bears the burden of tax or pays the tax. The history of taxation is almost as old as civilization. Taxes have existed in all the ages, only its character and the ways of implementation have changed. According to the Black Law Dictionary, taxes are the burdens or charges imposed by the legislature upon the persons or properties to raise money for public purposes. So the taxes are raised for public benefits. Nearly 2000 years ago, there was a decree from Augustus Caesar that all the world should be taxed. In ancient Greece, Germany and Roma empires, taxes were levied on the basis of occupation. In northern England also taxes were levied on land and movable properties. So the taxes are levied by almost every country of the world. Normally taxes which are levied are of two types, direct and indirect. The power to levy taxes has to be expressly provided by the law of the country. In Indian context, the Constitution of India Article 265 expressly provides that the taxes can be levied or collected only by the authority of law. Taxes serve as a primary means for various important objectives like maintaining law and order, public infrastructure, financing subsidies, setting up educational institutions, incentives, research and development, so and so forth. The concept of levy computation collection of tax is different in different countries of the world. The system of levy of tax in each country was a self-contained code. However, in the late 19th and early 20th century, when the foreign trade was expanding, different jurisdictions started interacting with each other. Such interactions led to harsh consequences of jurisdictional double taxation. That means tax was levied in the country of source and country of residence on the same income without any kind of relief provided by either country. Domestic tax laws were unable to fully resolve the issue of double taxation. So a need was felt to determine the basis on which country should exercise its right to tax these international incomes. This eventually led to evolution of double taxation avoidance agreements DTAAs, or to say tax treaties, which on one hand limited the rights or modified the rights of a country under domestic tax laws to a certain extent in order to respect the rights of other countries, and on the other hand provide for exemption or reduction of double taxation normally by the country of residence. Besides avoidance of double taxation, DTAAs seeks to develop economic relations between the countries so as to enable free flow of capital, technology, know-how, exchange of information, assistance in collection of taxes between the treaty partner countries.